Good evening, everyone. The time is now 5 p.m. I will go ahead and call to order the special called meeting for the purpose of concluding the meeting, our regularly scheduled meeting that was prematurely adjourned on last Monday. At this time, and again, calling the meeting to order at 5:01 p.m. At this time, I invite all those willing and able to rise with me to say the pledge. Pledge the allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Hopefully everyone on the dais has had an opportunity to review the proposed agenda for this meeting. Does anyone have, I know I potentially have a motion depending upon what you all have to offer, but does anyone have any proposed revisions or proposed amendments to the agenda? No, okay. Mr. White, our counsel reached out to us earlier today with respect to a set of voter challenges that were submitted to us on last Friday, on the 13th. Mr. White, so in your email, you indicated that you felt that we should go ahead and take this up based upon information that Director Fall shared with us on the afternoon. So we received received them, I guess this is, not yesterday, but Friday, and around 12:35, and then I know Ms. Fall provided us with some additional information around 4 o'clock. And I believe it was your suggestion that we could take them up now because no communication had been sent to Mr. Williams in the intervening less than business day that we've had since he submitted it.
Right. Well, it's really more of an interpretation of the state code that talks about making the determination immediately. And so this, we received them Friday afternoon and then or Friday during the day, and then I think the staff looked at information about the voters and sent us what information they could find, and including that all of them are on the inactive list. So my recommendation is to just go ahead and handle it today with the others, just so you can meet that statutory 21-230 requirement that the board immediately determine probable cause. Although this one's going to sort of fall under that
dismissal,
under the rejection for all the voters being inactive. But staff can talk about, or Ms. Fall can talk about that when we get to that item. But I would suggest adding it. You can either add it as a, to the probable cause determination list here under new business, or create a separate item for it.
Okay. That being the case, and thank you for that explanation, in my annotated agenda, I was just proposing that because they are, it's slightly different in as much that all of the individuals that were challenged, all the voters that were challenged are inactive, whereas the two probable cause determination or the two sets of challenges that are subject to a probable cause determination during this meeting have a combination of both active and inactive. I would propose that we amend the agenda to add one additional item under new business for the purposes of taking up Mr. Williams' Section 230 challenge submitted on the 13th, wherein 12 voters were challenged based on residency. So that's the proposed motion.
So moved.
Thank you. Is there a second?
I'll second. Let's just also clarify it's 11 voters.
Oh, that's right, because I was counting the header. 11 voters. So you've got that correction noted, Ms. Efron. Okay, so it has been moved and properly seconded to amend the agenda to add the September 13th Section 230 voter challenge as submitted by Mr. Eugene Williams. All of those in favor?
Madam Chair,
Yes, I'm sorry.
could we have discussion
Yes,
first?
I apologize. Go right ahead.
Since we're adding this, should we also add the other two challenges that have yet to set a hearing date?
Those are you referring to the ones noted as submitted by Mr. Williams on August the 26th?
Yes. And the 23rd, I think, or
No, the
something like
20,
that.
he submitted one on the 26th, and then he subsequently submitted another on the 28th, and then revoked it, if you will, and said that he wanted to resubmit that same information, supplementing it with some additional information on the 29th. I have them right here. But they are actually noted on the agenda. The 1-2 second item under new business.
Okay,
Yeah, they're on.
okay, thank you.
Okay, you're welcome. Pardon me, I should have called for discussion. Is there any further discussion before I call for the vote on amending the agenda to add the September 13th challenge? Hearing none, now I will call for the vote. All those in favor? The motion passes unanimously. Okay. So that agenda item, I believe it's most appropriate placed after the probable cause determination line item, but prior to the board resolution, such that we're all handling the challenges all at the same time before we move on to other business. That being the case, our agenda has been amended. So I would be remiss if I did not take the opportunity to address what transpired at this meeting last Monday. I'm fairly certain for those of you that were present, or for those of you that have read about it, or for those of you that have perhaps seen the video, I and others were extremely troubled by what took place, and I'm also extremely hopeful that notwithstanding our differences, you all have heard me say this on several occasions, we can disagree without being disagreeable. And this place, this meeting, there is no space for that type of language, whether it is based on religion, whether it is based on race, whether it is based on national origin. It's just not a place for that here. Who we vote for is partisan. The opportunity to vote and the work that this board does is nonpartisan. And so, again, I would just hope that that type of language, that type of hate speech would just not find its way here. I am grateful for the presence of law enforcement. And for those of you that have participated in these meetings, for a period of time, I would start the meetings imploring you, really, to engage in a civil manner. For those of you that know me and have gotten to know me, I'm a lawyer. My profession is grounded in civility. There's a certain level of professionalism that I am just accustomed to, coming out of just the way in which I was raised and also what I do for a living. And admittedly, I'm a bit appalled and continue to be appalled at exactly how uncivil folks are that come to this meeting. So I would like to briefly note, I appreciate the chairwoman of the Board of Commissioners, as well as the chairwomen of both the Cobb GOP and the Cobb Democrats for speaking out and issuing statements that are in line with the positions that we took when we determined it was appropriate to adjourn the meeting. And so again, I personally, if it gets to that point, we will stop. And we've got a lot of work to do. I mean, this election is, what, I believe 49 days away. We really don't have time for that. So with that, I am going to break from the agenda for just one moment. I do recognize that board comment is noted at the conclusion or towards the conclusion of this meeting, but I'm also very aware that there is one member of this board that was probably, or not probably, absolutely, particularly more struck by the anti-Semitic sentiment that was expressed, and I do want to give her the opportunity to share, if you would like to, Ms. Mosbacher.
I'd like to take a few minutes to introduce myself and tell you a bit about the impact of last Monday's events. My name is Jennifer Mosbacher. Outside of my position as Vice Chair on the Cobb County Board of Elections, I'm a mom, a wife, a daughter, a sister, a friend, a small business owner, and a Jew. When I was in high school, my family sent me on a program called the March of the Living, where I traveled to Poland. I stood on the train platforms where Jews were deported. I stepped through the gates of Auschwitz, where the tree branches grow straight up towards the sky, as if trying to escape the horrors that happened there. I stood at the glass in one of the museum-like rooms piled high with suitcases to find one bearing my maiden name, Gross, glaring back at me. The first of many tears would stream down my face on this journey. We marched with thousands of Jewish youth and aging Holocaust survivors from Auschwitz, the work camp, to Birkenau, the death camp, on Yom HaShoah, Holocaust Remembrance Day, as a tribute to the victims of the Holocaust. As we marched in silence, hand in hand with each other, police lined the streets to protect us from the local residents throwing rocks, shoes, and spitting at us on our 3-kilometer journey. When we arrived at Birkenau, we prayed at the crematorium where over 300 corpses a day could be burned in the furnaces. I stood with my peers in the gas chambers of the Majdanek concentration camp, where the shower walls are riddled with fingernail scratches from those trying to claw their way out in vain. As I exited the gas chamber, we walked up the steps of the enormous mausoleum where 15 heaps of ashes found on the premises had been preserved. In Polish, the message, "Let our fate be a warning to you," is engraved. Those ominous words rang loudly in my head last Monday like a fire alarm going off. An alarm that started in a low pitch as a public commenter invoked a racist and xenophobic trope about Haitian immigrants eating cats. Rhetoric that has roots in the Jewish blood libel claims that became part of the Nazi propaganda of the 1930s. To a much louder siren as another audacious commenter called me a communist Marxist. We only have to fast forward a few decades to the era of McCarthyism in this country to understand the anti-Semitism entrenched in calling me, a Jewish woman, a communist. When an audience member yelled out Heil Hitler following these two incidents, while wildly egregious and eye-popping, upon looking back at the day's events, it makes sense, right? Can't we all agree, in a room swirling with anti-Semitic vitriol, it only makes sense to invoke Hitler, the perpetrator of the most heinous acts of anti-Semitism in history. So let me explain what really gets me. Here in this room, several people called for the person who said these words to leave. Not only was the individual unable to accept responsibility, own up to the hateful speech, and exit, but a room full of people sat in complicit silence. A silence that frightens me. A silence that screams we have forgotten the depths of violence and human atrocities where hate speech can lead. Let our fate be a warning to you. One last anecdote to help you understand why confronting anti-Semitism is my legacy. On the morning of Sunday, October 12, 1958, at 3:30 a.m., the temple on Peachtree Street in Atlanta was bombed. My mom would have been in that building at religious school that morning, only a few hours later. This is the temple where my great-great-grandfather had been rabbi for 51 years, from 1896 to 1946. He was instrumental in fighting rampant anti-Semitism and advocating for civil rights in the city of Atlanta. Rabbi David Marks's values live inside me and inspire me in my life. He took risks in leading the Jewish community, and today the temple still stands for those values. Atlanta and Cobb County may not always have been a welcoming place for Jews. In fact, Leo Frank, a Jewish man and member of the temple, was lynched by a mob that included prominent citizens, political elite, and business leaders less than a half a mile from the Cobb Elections Office. But there is hope that we can do better. I dedicate every ounce of my available time to ensuring that citizens of Cobb County are afforded an opportunity to vote. I believe staunchly in the right to freedom of expression and speech. But I also believe that embedded in the right is a responsibility to tolerance. We must be tolerant of each other's differences and use respectful language to express our concerns. I challenge everyone in this room today, everyone who was here last Monday, and anyone listening to call out hate when you witness it and practice tolerance. Hateful speech begets more hateful speech and ultimately leads to violence. While everyone seems to be concerned about the Heil Hitler comment, I implore you to look deeper and see the greater evil that permeated this room last week. I hope that all the individuals who invoked anti-Semitic speech now have a better understanding of why these words are so impactful and hurtful to not just me, but our entire Jewish community. I hope all public commenters at our board meetings understand that I will continue to call out hateful, threatening language and hold you accountable for your words. Thank you.
Thank you, Mrs. Mosbacher. At this point, we will resume at the point at which last Monday's meeting concluded. We have minimally 2, potentially 3 public commenters that did not have the opportunity to speak. One, in as much that she did not receive the link, and then 2 others because, again, we concluded the meeting. CP, is Ms. K. Joseph on? Okay. Ms. Joseph, can you hear me? Okay. We will come back to her as I know that she received the link and you say that she's on. It was Ms. Grubbs and Ahmad Salih. I don't believe I see Mr. Salih. Ms. Grubbs, you can come to the mic, please.
Thank you, board members. My name's Sally Grubbs, and I'm the chairwoman of the Cobb Republican Party. And my comments are going to vary a little bit from what I was going to say last week. I would like to read my statement. The comments made at the Board of Election meeting in Cobb County on Monday, May 9th, it was wholly and unacceptable to be uttered in any way, much less in a public meeting. While I'm a full defender of the First Amendment to the Constitution, incendiary comments, as the one shouted from the back of the room at the Board of Elections meeting, immediately made me sick to my stomach. There is no place for anti-Semitic comments in our community. As I've stated previously, I will state again that I stand with the people of Israel and condemn the heinous acts of the Holocaust, as well as the action of the coward who failed to come forward and take responsibility for his words. I very much stand by that, and my first job as a 16-year-old when I got my driver's license was actually at a Jewish clothing store right on the opposite corner of the square. And to think that that's okay is wrong. As far as the First Amendment goes, that stands with someone's right to stand or not stand for the Pledge of Allegiance. And we all have our personal journeys, and I respect the fact that while it may anger some people, we never walk in someone else's shoes. So I want to say that as far as I'm concerned, I am very upset that the person had enough nerve to say what they said but didn't step forward. And I agree. Sometimes we just have to agree to disagree, but we can do it in a kind and loving way. So know that from my heart. As far as the issues that I wanted to speak on, I understand that there's a resolution to not comply with the SEB rules. The SEB rules are in accordance with Georgia law. And in my opinion, to do a resolution to not comply with the rules or any part thereof would not be a good thing. And I think that you would be compelled to comply with those rules. With regard to the voter roll challenges, I would like to know where it states that you cannot challenge an inactive voter. So I know that this isn't a dialogue, but I would ask that the board attorney please point that out to me. I would also ask respectfully that one of the board members, due to litigation, recuse herself from some of the issues that are coming up. If you're involved in litigation on a matter, I don't think you should be voting on those issues. I would also like to state that there is still inaccurate information in the voter rolls on the commission map. I don't know what you can do to fix that, but one of those things would be great to be fixed. And then the last thing is hiring people to work. Have we filled all the positions yet? I would like to know that, because I constantly get calls of people who need the job, so thank you.
Thank you, Ms. Scruggs. Okay, so Ms. Joseph says she's on. So Ms. Joseph,
Can you hear me?
yes, please, do speak up just a little bit, but we can hear you.
Thank you. Good evening. My name is Kay Joseph, and I'm a resident of Cobb County. I would first like to thank the board for ensuring that I have the opportunity to speak today. I would like to comment today about the pre-certification meeting that will be scheduled for November 8th, 2024. By scheduling this pre-certification meeting, the board is proving that it takes its role in complying with state law seriously. And as a Cobb voter, I'm truly grateful for that. Our state's election laws are crystal clear that the county shall tabulate and certify the election returns no later than 5 p.m. on the Monday following the election. As a voter, I would like to add my voice to support this legal duty. There is no room for refusing to certify the election returns, and supporting this legal process is highly crucial to complying with Georgia's election laws. If there is a concern about discrepancies in the vote totals, those instances have to be resolved in the court of law. The Georgia Association of Voter Registration and Election Officials recently issued a statement that they were concerned that adding additional regulations so close to the elections makes it harder for election officials throughout Georgia and also makes it confusing for us as voters. This is a crucial national election, and clarity and consistency is what we need at this time. I agree with and support the Georgia Association of Voter Registration and Election Officials statement, and I would like to add my voice to supporting the request that the State Election Board should not add any additional regulations so close to the election. Thank you so much for your time, and thank you for everything that you do.
Thank you, Ms. Joseph. And then the final speaker, I don't believe that Mr. Sully is here. I will note that if he is watching, I made every attempt to decipher his phone number, as well as looked at old sign-up sheets. And the numbers that we saw here, I reached out to him multiple times and was unable to reach him. So with the public comment portion of our meeting having been concluded, we'll move on to the first item of business. That would be the rescission of a previous vote with respect to a polling location change for Roswell 01. Mrs. Fall.
Thank you. So we'll pull up the map, and this was voted on at the last the August scheduled meeting to move Roswell 01 from a co-located precinct location at the Catholic Church of St. Anne to Northeast Cobb YMCA. Unfortunately, when we went to do more surveys of the site, we learned that the manager who had agreed to host us is no longer there, and that they did not seek appropriate higher level permission, and that they did not feel comfortable moving forward with hosting us for November. So we're going to stay at the Catholic Church of St. Anne, so we'll just rescind that vote, and then we'll stay co-located there, recognizing that those are two large precincts at the Catholic Church of St. Anne. So we'll work with our partners in the sheriff's office to make sure that we have appropriate traffic control going on around the church.
Okay. And obviously, we've been in conversation with the Catholic Church of St. Anne, and now that you're asking this board to rescind its previous vote, is there anything that you want to share with us with respect to communication with them?
Just that they're very understanding. They're one of our longstanding partners, and they understand the position that we're in and are more than willing to accommodate us.
Okay, excellent. That being the case, thank you for that. So obviously, we voted to relocate Roswell 01 based upon information that Ms. Fall just shared with us, we need to rescind that vote. Is there a motion on the floor?
I move we rescind the relocation of Roswell 01 to the YMCA and go back to the Catholic Church of St. Anne.
Thank you, Mr. Bruning. Is there a second?
Second.
Thank you, Mrs. Fisher. Is there any discussion? No? Okay.
Just want to
Yes.
confirm that nothing was ever sent out to the voters to tell them of the change, so we don't have to tell them again.
Correct. So we haven't sent out precinct cards yet for any of the changes, because we'll have 2 more at the end of the month. And so we do have to advertise for 2 consecutive weeks prior to the board voting to move a polling place. So when we do advertisements for the locations we're voting on for September 30th, and the advertisement just says that the board will be voting to move. So we'll have those 2 advertisements. We're also going to do an advertisement that says that Roswell 01 was not relocated to Northeast Cobb YMCA and will remain at the Catholic Church of St. Anne. So that's in the legal organ for 2 weeks before the September 30th meeting.
Okay. Thank you for posing that question, Ms. Afrat. Further to that point, I understand that there was no communication beyond obviously the advertisement that's required to be placed in the public organ in the Marietta Daily Journal. Do you think it's advisable to place some signage? Maybe we can get some permission to place signage at the YMCA?
Yes, yeah, we talked about doing that, doing some large yard signs there, just so people are aware that that is not a voting location. So we'll be sure to do that.
Okay, excellent.
Thank you.
Unless there is further discussion, we'll call the question. All those in favor? The motion passes unanimously. Thank you. Moving on to the next item on the agenda would be the approval of our regular board meeting minutes, that being the meeting of August the 12th. Has everyone had an opportunity to review the meeting minutes? And to the extent that everyone has reviewed it, are there any comments or concerns or proposed revisions to the meeting minutes? Hearing none, I'll entertain a motion to approve our August 12th regular board meeting minutes.
I move that we approve the August 12th board meeting minutes.
Is there a second?
Second.
It's been moved and properly seconded to approve our regular board meeting minutes. If there is no discussion, all of those in favor? The motion passes unanimously. Moving on to new business. The amendment of our 2024 board meeting schedule to add November 8th, 2024 pre-certification meeting.
So this is in compliance with the new rule that was passed by the State Election Board, where we'll have that Friday pre-certification meeting at 3 p.m. And so we're looking at adding that. I don't know if we want to have discussion on the location now or later. We've gone kind of back and forth talking about it in the office. This is a great location because we have the much easier ability to stream. But I think as we'll still be receiving UOCAVA votes and provisional certifications up until 5 p.m., in order for me to get y'all the most accurate information while we're in that meeting, it will really need to be at the office. And so that's just kind of a consideration when we think about location. But this will be Friday, November 8th at 3 p.m.
And it's prescribed by, as set forth in the new SEB rule,
Yes.
that it must be by 3 p.m.
Right,
The meeting
yes.
must be held by 3 p.m.
Yes.
Okay. Does anyone else have any questions for Ms. Fall with respect to her ensuring that we are complying with recently adopted SEB rules with regard to the pre-certification meeting? Yes, sir.
I had a question. What information is going to be available at that meeting?
So by that time, we will have all of our provisional ballots that were out of precinct. We'll have those results ready because they'll have all been transcribed by the vote review panel. We'll still be waiting on any provisional ballots that are requiring proof of ID or proof of citizenship. They have until 5 p.m. on Friday to send us that or to bring it in, so we'll still be waiting on that. We'll have the majority of our absentee by mail ballots, still holding out for any possible UOCAVA ballots that meet the postmark deadline. We try to communicate with our post office so we know if there's any coming by 5 p.m. So we'll have an idea of what those final vote totals are, but there'll really still be 2 hours where that could change. I can't imagine by a lot, but could still change. So we'll have tentative vote totals.
Will the numbered list of voters be available for that?
Traditionally,
Meeting?
in the elections that we've had this year, the numbered list of voters wasn't available until the Tuesday after the election. So I'm not sure if the Secretary of State is planning to change that, if they can, because of this new meeting. But in all the elections we've had so far this year, the numbered list has only been available the Tuesday after the election, so the day after certification.
And can you verify, because I believe I was told that that comes from ePulse and not Jarvis?
Correct, it comes from No Inc.
Okay,
But I can follow up on that.
okay, thank you.
And to be certain, excuse me, following up on that, that discussion, is Cobb County a party to any contract that you know of with No Inc.?
We have a sole source agreement because we're on the state contract with them, but we don't have any independent contract with them. It's just because they're the sole provider. We don't have a choice when it comes to the poll pads, so.
Right. And as it relates to the provision or the retrieval of the numbered voter list that Ms. Fisher was requesting, do we, the elections office, Cobb County Elections Office, have the ability to vary that time frame within which they provide it to us, make a request sooner?
I don't believe so because it goes out to everyone at the same time when the file has been prepared.
Sure.
And so we just get a notification that it's ready
And we get that notification from whom?
from No Inc. directly. It comes from No
Okay.
Inc.
Do you know anything about the communication between Secretary of State and No Inc. with regard to the timing of the provision of that list?
No, I'm not familiar with that
Okay,
discussion.
okay, thank you.
Is a similar style list available to be ran through Jarvis?
I don't believe at that time because we haven't assigned provisional voter credit yet.
Because why?
We haven't assigned provisional voter credit yet.
Oh,
so
I thought
we-
you said we would have that
No,
by the
We typically
meeting.
do that after 5 p.m. on Friday, once all the provisional ballots are in place. That way, we don't miss any, when we're going back and forth as they're coming in. There is a new provisional module within Jarvis that will help with that, where we can mark a voter as having voted provisionally, and then we can say whether the provisional ballot was counted or not. So that'll help, but I don't think we will have any type of voter final credit list at that point, at 3 p.m.
So you can run a report, but it wouldn't include provisional.
I'd have to double check with the team and see what would be available at Friday at 3 p.m. And so I can get with them and then get back with y'all about what we can pull from Jarvis.
Okay, thank you.
And as it relates to this particular meeting, I know that certain communication was received from the Secretary of State's office, the documents, and unfortunately I ran out and left them, that you shared with us. Was there any, I guess where he's certifying, if you will, the specific rules that were adopted, has there been any guidance with respect to what is to be accomplished at this meeting on the 3rd, or on November the 8th, to the extent that we won't have complete information?
Yeah, we did receive guidance today on the rules that had been passed, as well as information that there's another meeting this Friday with 11 proposed rules. The guidance talks about 3 rule amendments. There's one paragraph that talks about certification. It doesn't really have a lot of information. It does note in bold toward the end of the paragraph that all county superintendents are required by law to certify returns by 5 p.m. on November 12th, 2024. And then compliance with the certification deadline is critical for timely state certification and to allow candidates or voters to contest election results in court. And then it goes on to the next SEB rule. So there's no guidance on that 3 p.m. meeting.
Okay.
It just a general overview of what's expected of the board.
And you said you received that from the Georgia State Election Board today?
Secretary of State.
Secretary
Yep.
of State?
Yeah, this was guidance
It
from the
was on
Secretary of
BuzzFeed.
State
It was on BuzzFeed? Okay, got it.
this morning.
Did you happen to attend their last-minute webinar? Literally last-minute webinar?
I think it's tomorrow.
Oh, it's
Yes, tomorrow
tomorrow?
at 2 p.m.
Okay.
Yes, so I'll be attending that.
Okay.
They're gonna provide more guidance, hopefully, a little more meat and potatoes on the meeting specifically, and if not, I'll be sure to pose that question in the chat.
It's at what time tomorrow?
I believe it's 2
Two?
p.m.
Yeah.
PM.
Yeah, 2 p.m.
Okay. And then finally, you made reference to a new module, a provisional module in Jarvis. Has the Secretary of State offered any training on this new module?
There is a very light overview at the training we attended in Forsyth, Georgia a few weeks ago, where we got to see it, which was really exciting because it's something that our ABM team has been asking for a long time. But we have not had a webinar or anything of that nature to train us in terms of that piece. It
On
was
how to
just-
use this new?
Yeah, it was just
provisional
screenshots. And-
Okay.
And we're waiting on the slides that were given at that training. They haven't been posted to Firefly yet, so we're still waiting on those as well.
module? Okay, excellent. I don't have any other questions, and sorry if I felt like I was deposing you.
No, that was good.
Just wanting us to be very clear about the information that we have received versus what we haven't received as we work to support our director and the staff in compliance with rules that have already been adopted. And obviously, part of that compliance is this pre-certification meeting. So yes, sir.
Are we required to vote on anything at that meeting?
I don't believe so, based upon my reading of the rule,
Just curious.
as to the intent or what's to be
Yeah, what-
the objective.
Why are we meeting? On the
We'd have
third,
to ask the state
at 3
election
o'clock.
board and the proponent of the rule.
Yeah.
Yeah. So, but all that being said,
I just
I
have
mean, we would.
I just have to say, we won't have all the information.
No.
And we have no decision to make.
No.
vote. That's frustrating.
Indeed.
And it is 2 hours prior to the provisional deadline, so there won't even be complete information.
That part.
I believe when that rule was presented, the assumption was that any questions would be raised at that meeting, not the day of certification. That was my interpretation of what was presented by the rule maker. And
I think the confusion is, how would anyone have an answer to whatever questions are brought up if we don't even have all the ballots in yet?
well, you have everything except provisional, which.
And Uacava.
And Uacava, well, the last minute Uacavas, you have the vast majority, correct?
Depends. They have a legal right to.
Yes.
For that, we talk about legal
Yes.
rights all the time.
Yes.
They have a legal right to have their ballots counted as long as they're received by 5 PM in our office, so.
I'm aware,
Okay.
but I do think that was the intent of the rule, if I remember, and I think it's a reasonable request.
Well,
So,
at this point, it's no longer a request, it's a rule, and we're attempting to
well,
comply
I
with
get,
it.
that is
So,
true.
that being said,
If I could add one thing
Yes,
on that
please.
note. That, this is the first time we've done this, obviously. So if y'all know of something that you want at that meeting, please let me know as soon as possible. Because a lot of times, before that certification meeting, it's happening live. Like, I'm printing it off and walking out the door to come here. So anytime you can give me during that week after the election, between, Wednesday morning and Friday at 3 p.m., to make sure I have what you're expecting to see, I would appreciate that, because it'll be a lift for us to get actual documents together by Friday.
I think what would be helpful would be to have everything that you're going to have on Monday, being really Tuesday, what you would bring to the certification meeting, but with dividers or colored sheets that say not complete, inserted, so we know what is presented that is done as far as we know, and then we know what's not done. So that would be the only guidance that I could offer is, give us everything that is done, so that if we have questions on it before certification, we can ask.
Got it. I can do that.
Great. And I will just add to that, Mr. Bruni, I think that's an excellent idea. I will note, having attended not the entirety of the discussion around these particular rules, but a portion of the discussion, the proponent of the rule had concerns about other documents. That was in part the basis, as I understood it, for proposing the rule, suggesting that what is provided to us, or has traditionally been provided to us, is insufficient, which then potentially opens up, a endless request of documents. So I actually agree with Mrs. Fall, and I would suggest and request of this board that, to the extent that anyone has a request for a document, to get it to her by Wednesday, such that she and her team have an opportunity to, or our team have an opportunity to pull those documents together in a timely fashion, as opposed to waiting to the last minute. And then obviously, depending upon what those documents are, what that information is, Mrs. Fall, you can let us know as to whether it's something that you have even available to yourself, using, for example, the report that Mrs. Fisher made reference to. That's not something that would be available, not in the way in which it's normally provided, because you don't receive it from the vendor, No Ink, until after this meeting takes place.
Right.
Correct?
That would be great. Yes. Yeah.
Okay.
Thank you. We'd appreciate that.
Absolutely. So I think the only other open item with respect, or point with respect to taking a vote is the location. Am I correct, Mrs. Fall?
Yes. If we want to go ahead and set that now, then we can go ahead and get it on the website, added to the calendar. That would be great.
Right, and I know that you noted a preference for having the meeting at the elections office.
Yeah.
And I personally would agree, but obviously want to open it up to any discussion with respect to the location. I know we try to stay here because this is much more accessible by the public, but I think in this particular instance, it'd be appropriate to go along with and accommodate the staff that will be providing us with that information to facilitate that meeting. Does anyone have any comments or questions about the location or the proposed location?
I move to vote to have the location be at the elections office to accommodate Ms. Fall's request.
Okay, so your motion would be to amend the 2024 board meeting schedule to add the November 8th, 2024 pre-certification meeting to be held at 3 p.m. at the Cobb Elections Office?
Yes.
So moved.
So moved.
Yes, thank you. And is there a second?
Second.
It's been moved and properly seconded to add the required November 8th pre-certification meeting to take place on November the 8th at 3 p.m. at the Cobb Elections Office. All of those in favor?
Can we have a discussion,
Oh,
please?
absolutely.
Okay.
We called for discussion, but go
Well,
ahead.
I put my thing
Oh,
on.
I didn't see.
I just didn't get called on
No worries.
before the motion. I would request that if at all possible, that we be able to stream it out to the lobby, if nothing else, if there is overflow for the public that may or may want to attend that may not be accommodated. I'm assuming it'll be in the boardroom, in the conference room?
Yeah, that would be easiest.
Okay. I would just request that we at least offer that ability rather than turning people away from the room.
Yeah, previously, when we've held meetings in that conference room that were regularly scheduled meetings, obviously not our election night meeting, we have streamed them. So, Mrs. Fall, if you will work with our comms department.
Yeah, we'll stream them in the TVs that are in the lobby. We can definitely do that, and then it'll be streamed online as well. So
Okay.
we can do that.
That also raises another point, and so thank you for raising that, Mrs. Fisher. When we have our certification meeting, there generally is an opportunity for public comment. However, when we have special called meetings, absent obviously today because it was a specific circumstance, we do not generally have time for public comment. And so I'm not entirely certain as to which type of meeting this would be. a special called meeting, or, because we don't generally have a pre-certification meeting, but I think that we need to set forth the policies and the procedures around public comment at this meeting. Because, you know, we know how we handle public comment at our regular meetings as well as at our special called meetings. So, not suggesting that it has to happen today, but we obviously need to do it in a timely enough fashion so that the public is well aware as to whether there will be public comment or not public comment. And I note that we are still in the midst of discussion preceding the vote on a motion, but thought it appropriate to bring that up. Mr. Bernie?
My only comment is that we're having the full meeting, the certification meeting, 4 days later. I would, and that is a cramped space.
Understood.
And so I would suggest we not have public comment at that meeting, instead have it at the certification meeting.
Which is where we generally have it, yes. Given the recent interest in making public comment at our meetings, I just thought it'd be best to get it on the table such that we're being transparent with the public. So, unless there is anything further, any further discussion, we'll go ahead and call the question. And again, that's the amendment to our previously approved 2024 board meeting schedule to hold this November 8th pre-certification meeting at 3 p.m. at the elections office. All those in favor? The motion passes unanimously. Okay, thank you all for that. Moving on to the next item on our agenda, we made reference to it earlier. We have received a number of voter challenges submitted under Section 230 of the Georgia Election Code. One received on August the 26th, a second received on August the 29th, and those are the two that we'll take up in this agenda item. Ms. Fall, I know that, well, one, thank you and the team for your support and your assistance in doing diligence and reviewing the information, making certain that we have everything that we need. Before we get started, Mr. White, this being a probable cause determination, as you've shared with us, is there anything that you would like to share with the board before we undertake this discussion with respect to probable cause?
Sure, yeah. I'm going to just kind of just remind the board a little bit about the 230 process and sort of what this step is. And it's just a reminder, there's two types of challenges. There's 229 challenges, which can sort of occur at any time. And then 230 challenges are ones with respect to a specific election, and they're challenging people's ability to vote in this specific upcoming election. And there's some new amendments that were passed just this past year by the legislature with regard to that. And so, but just in terms of basic process, one thing that did not change is that the board's first step with regard to these challenges is to, there must be a showing of probable cause to decide whether to move forward with the challenges. And so I'm just going to read to you from the policies and procedures that were adopted, just to remind you, and this is in Section 2D. In order for a challenge to proceed to a hearing, there must be a showing of probable cause. To meet the probable cause standard, the evidence presented in support of the challenge must be reliable and credible non-hearsay evidence that substantiates the claims made in the challenge. And then it lists some things. It says the following shall not be sufficient to sustain the burden of proof. It talks about information gathered from social media posts or door-to-door surveys. A change of address, things on its own is not sufficient. And then attempts to connect a registered voter to the record of a person with the same name and partial birth date will not be enough on its own because of the risk of false positive identification. And then number 4 talks about if it's based on a challenge that the voter did not live at the address at the initial time of the registration, that fact alone won't be sufficient. So there's just sort of a list of 4 things that, you know, at the outset would not be considered by themselves probable cause. I do want to make a note and say this is one thing that needs to be amended in our policies, either today or just at a future date, we can do that. But I think this is a holdover from some other from another one, but there's a reference to non-hearsay evidence. I just want to point out that for probable cause, hearsay evidence is allowed. One, that's just as a general matter of law, in criminal probable cause hearings, which is not really the same as this, you will allow hearsay evidence. But the other practical reason for not getting into that distinction is you guys don't want to be the judge of you don't want to have to hear me explain what is and what is not hearsay evidence. So I'm just going to point out that that's in the policies, but I would ask you to disregard that, and we need to probably have the board amend that at some point. So the step, all that's to say, today the board has to make a determination as to whether to move forward with the challenges submitted by Mr. Williams on August 26th, and then another set of challenges submitted on the 28th and resubmitted on the 29th. And because the 21-230 says that the board shall immediately determine, the way we've read that in the past, that is at your first available opportunity, you'll make a determination of probable cause. And since the board has to act in the context of a meeting, this is your first available opportunity. And so today, you'll make a determination as to probable cause.
Okay. Thank you, Mr. White. Are there any questions for Mr. White before we?
I do have a question. Per 21-2-217, it clearly lists homestead exemption in another state. It doesn't call it probable cause, but it certainly lists that as a reason to be able to remove an inactive voter. So my question to you would be, I think several of these challenges do involve a homestead exemption. So I would like your position on how we can say no to that when 21-2-217 actually lists that as a legitimate reason to remove an inactive voter because they are no longer eligible.
Well, Ms. Fisher, let me just say, I'm not sure, I don't know if we're at that point in the determination yet, because I think what probably needs to happen is staff needs to cover what's alleged in the challenges in the list, and then the board needs to ask questions about that. I'm not aware of any predetermined, that hasn't come up because that hasn't been presented in this meeting yet, so.
Right, I was
Kind of
inquiring.
jumping to a conclusion.
Well, I think we
If
are.
you will, when I inquired as to whether anyone had questions, it was about what Mr. White shared with us. The next step in this process, to Mr. White's point, would have Mrs. Falls share the information.
So what I ask you wouldn't consider to be a probable cause question?
I'm not suggesting that it is
Okay,
not,
all right.
but there was a reference to dismissing things, and we've not suggested that we were dismissing anything at this point. It was just really setting the predicate, if you will, for the discussion, in as much that now I believe that it's appropriate for Mrs. Fall to share what she and her team were able to locate.
Sure. So on the challenge that was submitted on 8/26, which was on the basis of homestead exemptions under 230, there were 178 voters listed in that challenge. Of those, 13 are active voters. The rest are inactive. And then on the 8/29 challenge, that was also at 230, the basis of voters who were registered in Cobb, also registered in the state of Florida. That had 2,939 voters on it. Of those 2,939, 176 are active registered voters in Cobb County. So that was kind of the two overviews of those two.
Okay. And,
May I add just one thing to
yes,
that?
go right ahead.
I just did a little bit deeper dive, so I also do want to say on the 826 challenge, of the 13 active voters, actually only 6 of those are new that haven't previously been challenged in other lists. And
I'm sorry. You said, so
So
of the
we're-
13, 6 of those are new challenges?
Actually, only 6 of them are new voters that have not been
New
previously
voters.
challenged.
Okay.
Yep, so we've already dismissed 7 of those 13 previously.
And would you happen to have the timing within which,
I got good spreadsheets for you.
I know you do.
But I'll just address also the 829 challenge. only 29 of those 176 active, only 29 of them have not been challenged before. So these are repeats that we've actually already seen and dismissed.
Okay,
So of the 826, there's 6 new, and 829, there's 29 new.
okay.
Weren't they previously challenged under a 229, not a 230?
Sure. they're
Well,
just not-
there is a requirement of us to hear it under the
There's a
new
requirement to determine probable
present.
cause.
Excuse me.
So
It-
she was actually in the middle of a sentence, so you were suggesting that 6 new voters were challenged under, on the 826 challenge of the 13 that are noted as active. 176 of the 2,939 voters that were challenged per the August 29th submission, of those 176 that are active, 29 are new voters that have not subsequently, that we have not subsequently dismissed a challenge to them.
Just further information, yes,
Okay.
that's correct.
Yes, now,
They were dismissed under a 229, not a 230. I do think they should be entertained under a 230.
okay, and I think that is the purpose of us at this point, having this probable cause determination. However, that does raise a good point with respect to the law. Mr. White, 229 challenge, the challenge was dismissed as to a number of these voters that are listed as active. We are subsequently coming back or someone is subsequent, Mr. Williams is subsequently coming back and has resubmitted them for a challenge under 230. Obviously, we know the distinction between 229 removed from the roll versus the inability to vote in this current upcoming election, correct?
Correct.
Okay. Any guidance or further guidance you want to provide with respect to the point Mrs. Fisher made?
You know, any voter, including Mr. Williams, is, you know, he can submit them again. And I think this is probably a good time to point out, though, one other concern that the board needs to address up front is the 90-day window under the NVRA, and that would have been August 7th, I believe, would have been 90 days before the election. And so another concern that's sort of set forth in the rules is, it's in section 1D4, and it talks about pursuant to the NVRA that any systematic list maintenance process shall be completed 90 days prior to the date of a primary or general election, and that the 90-day rule would be applicable, for example, to a challenge against voters which is created by a process that compares information from one database with information from another database. And if the board determines that the challenge is subject to the NVRA's 90-day quiet period, the board shall reject the challenge and without need to set a hearing and give notice. And I want to just really quickly, for people who don't know where that comes from, that comes from a 11th Circuit case. It's not something the board just made up or just adopted wholesale. And it talks, this is Arcia, the Arcia, let me give you the actual full site here. Arcia versus Secretary of Florida, and that's a 11th Circuit Court of Appeals case from 2014.
Can you give me the site?
Sure.
Just for our
It's
notification.
772 F. 3rd, 1335. There's really two cases I want to talk about here, but that's one.
What was the last, you said 1335, page number 1335?
Yeah, 772 F. 3rd, 1335.
Okay.
And that one, you know, it's a little, that's more talking about a statewide program. It's talking about a Secretary of State in Florida using, basically comparing citizenship databases and another database, like saying, but this is where they give the definition for systematic, and it talks about a systematic program that did not rely upon individualized information or investigation to determine which names from the voter registry to remove. Rather, the Secretary used a mass computer data matching process to compare voter rolls in other state and federal databases. So I'm going to be upfront, like that's clearly applying this to a statewide program. So it's a little different than what we're talking about here. But then we also have the Ben Hill, Majority Forward versus Ben Hill Board of Elections case, and that's a middle district case from 2020. And there's also Muskogee County was involved in that same case. And that applies the language from the Arcia case, talking about systematic voter list maintenance, and it just adopted it, straight from Arcia, and said that these mass voter challenges, in that one, there were 2 different challenges. There was one of 4,000 voters submitted, and then there was another one that was a smaller one of only 300, and only 128 ended up moving forward. So it's not just the 4,000. The court also applied it to the ones that are in the hundreds and said that type of database matching is a systematic inquiry and not an individualized inquiry. So it's up to a voter that's challenging other voters to provide that individualized information if they're going to ask for those voters to be removed under the challenge process. So the board does need to consider today whether the information that was submitted by Mr. Williams falls under that systematic type of process, because people want to draw a distinction to say, well, that's a prohibition on the state doing that, but there's no rationale to say, well, we would allow a citizen to undertake a systematic voter removal process that a state can't also do on its own. I mean, that doesn't, we're going to just allow a citizen to come in and do a systematic process would not be appropriate either. So that's what the Middle District, the majority Ford versus Ben Hill County, that's what the Middle District of Georgia said in that case. So I just felt like that comes up. People ask me about that, both from the board and from member comments, and I want people to know that language is not in the policy because the board just decided that's what it should be. Those are taken from 2 cases directly, and that language is adopted based on that.
Weren't those 2 cases for removal?
What's that now?
Weren't those 2 cases based on removal? Removal of the voter? Weren't they under a 229 challenge? I believe that was on removal, and there is a distinction.
Well, the first case wasn't on a 229 at all. It was on a
Systemic, I get it, but we are on the 90-day period, I guess, is what stumped me here, because these are not removals under a 230.
Well, they're intended to lead to the removal but because what they're asking you to do is to find that they're not eligible to vote in this election and to set them for a hearing to move them forward towards removal.
They are given the opportunity to prove they live here. So they can still
Right.
vote if they bring proof that they still live here. So
Well-
there
I
is.
think that supports actually leaving inactives or not dismissing or removing inactives, because inactives are given an opportunity to demonstrate that they are eligible to go from the inactive list back to the voter roll, because as I understand it, there's the maintenance of 2 lists. Am I correct, y'all?
An inactive just walks in, shows an ID, could be a utility bill, and is able to vote. If they're challenged, they have to prove they actually live here. So there is a difference.
Well, I mean, those 2 cases are on there, and that's, I would say, under the 90-day list maintenance provision. I still think it would apply to 230, but it also would also go to the board's determination of, is it reliable enough? The standard is credible evidence, and is it reliable enough for the board to move forward with it? Just a database matching process.
So you're saying Ben
probable
Hill
cause.
is not based on the removal of a voter?
No, I think the 230 process, that's the intent of the challenge is to move it forward to the removal process, which is, if you go look at the statute, the state has now added a 45-day limit to push push these things, consideration of these, out past the election if they're filed. And there's some gray area in there about whether it's received before or after for the 45-day one, but I'm just bringing up the 90-day provision just so you'll consider it, both in terms of the prohibition against list maintenance, but also you can consider it in terms of the credibility of the evidence that's been gathered.
Well, just so it's clear to everybody watching and in the audience, a 230 does not remove a voter. And a
It's
challenge.
It's a precursor
It
to
is.
the removal, correct, Mr. White?
They would have to bring it back under a 229 to remove them.
hence the fact that I'm referencing it as a
They would have to
precursor.
bring it back as another challenge under a 229.
Right. Well, Debbie, let me just point out this way. You're also not allowed to initiate the list maintenance process as the county elections. There's, like, in other words, you're not allowed to send out the cards, and the cards themselves are not a removal. Like, they'd have to respond, or you'd have to put them on the list. Like, that's not removal. But that's also expressly prohibited under the NVRA list maintenance thing. So the fact that it's just an initial step, in your opinion, doesn't really make a difference here. If it's intended to lead to the removal of potential voters, then it's still part of the process.
Well, we'll just have to disagree on that because there is a big difference between a 229 90-day quiet period and a 230.
Okay. Don't know whether it's relevant, but I will note that the Department of Justice did issue some guidance this month, actually, with respect to the prohibition against this type of systematic removal. And it specifically notes that the deadline also applies to list maintenance programs based on third-party challenges derived from any large computerized data matching process.
I read that, and again, you're talking removal.
Right, it, actually, the memo talks about the challenge. If
Yeah.
you want to read it, it says, deadline also applies to list maintenance program based on third-party challenges derived from any large computerized data matching process. And this is, the title of 21-230 is the challenge of persons on the list of electors by other electors. So this is a voter-elector, this is a elector challenge filed by other voters, and it's part of the list maintenance process because it can lead to the removal of voters. So I think the 90-day version, at least according to the Department of Justice, would apply here.
So is there any further, are there any further questions either for Mrs. Fall? And again, thank you, Mrs. Fall, for providing the information you provided, as well to you, Mrs. Mossbacher, and for you, Mr. White, with regard to giving us a clear sense of what is being asked of this board with respect to making a probable cause determination. Any further conversation or discussion that we think is necessary at this time? Okay. So I guess the question before us is as to whether we believe that there is probable cause. Well, it's a two-part question. With regard to the August 26th challenge, 178 voters, of which 13 are listed as active. So happy to entertain a motion with respect to those active voters, because per our policy that we adopted, those inactive voters, we are dismissing the challenge as to those voters. Correct? Okay. So this is a probable cause determination that's before us. Is there any motion with respect to whether there has been a finding of probable cause with regard to those 13 voters that are listed as active in the August 26th challenge?
I do fine. I move that we approve the 13 voters that have been deemed to be active and legally challenged to move forward. There is probable cause for all 178, but my motion is for the 13.
So let me just parrot back your motion so that I understand it. You move to find probable cause with respect to the 13 voters that are listed as active that were a part of the August the 26th challenge as submitted by Mr. Williams?
Correct.
Okay, thank you for that. Is there a second?
I have a question first.
We're in the middle. I'm sorry, I'm a Robert's Rules of Order girl. Is there a second?
I'll second so that we can move forward.
Okay, it's been moved and properly second. Is there discussion? Go right ahead, Mr. Bruni.
Daniel, does the 90-day rule not apply to these 13 voters?
I think it does. I think you apply it to the entire, because it was gathered under a list maintenance process, like, or another list matching process. I looked at this one to see what individualized information was presented. I would think from a legal standpoint, it would be subject to challenge if the board moved forward for it, but you can also, and it also might be stronger if you just make your own credibility determination as to, instead of just relying on the 90-day provision, you could also make your own credibility determination to say that whether you find the evidence submitted credible or not, and whether there's probable cause. I will just say from a legal standpoint, I think it would be, if the board moved forward with it, it could be challenged in court under the 90-day provision.
So,
Can you reference the law that states that versus what is the challenge here on a 230? The 90-day rule under the National Voter Registration Act is literally for the removal of an eligible voter. If I'm not mistaken,
Actually,
the 178, I believe, is attached to an entire list of people who have homestead exemptions in other states. If they can prove they still live here and have a homestead here, and this is their resident, then they can stay on the voter roll. But the law says you can only have a homestead exemption in one state at a time. If I'm not mistaken, this particular challenge is all about homestead exemption.
So I'm just going to.
So please point to the rule that the 90-day or the law where you think it applies.
Okay, I kind of already referenced those two. The Arcia case talks about systematic list maintenance. It doesn't say, it talks about the 90-day NVRA rule and talks about systematic list maintenance. Same thing in the Majority Ford versus Ben Hill, and it talks about programs and systematic removal under the NVRA. And I know you keep saying that 230 is just about challenging before the election, but if you read the entire, it's literally.
I've read the entire.
Just let me
Debbie,
finish, Debbie.
we have to be polite to
I know
each
you
other.
don't-
We can't ask the folks that come here to be polite if we're going to interrupt each other. We can't do that here.
You're right.
So I know you don't agree with my reading of those cases. I would suggest you go read both of them. And but those two cases, but also under 230, that entire section, it's just you're sort of drawing the line at the first step and saying that's the whole process. But you have to read the entire statute because it goes through in sections. C, D, E, and F says, here's the next steps you follow after you initiate this process and determine probable cause. And so one of the outcomes, depending on whether there's probable cause, is that it moves to removal from the voter list. So to the extent someone has submitted two challenges, the challenge over 3,000 people, a large number of which could end up in the removal process, it is part of a program of list maintenance to the extent it's done systematically instead of individually and someone coming in and filing individualized information based on their personal knowledge, then that's and it doesn't have to be necessarily on personal knowledge, but it just has to be on evidence that the board, individualized evidence that the board finds credible.
I think what we're missing here is what is an individualized challenge? Because in my opinion, when you have proof that the homestead exemption has been filed in another state, you have the voter living in that state with the address that belongs to the homestead exemption, you have their Georgia address. How is that not individualized? Can you define what an individualized challenge would look like?
Well, I think if you read the Majority Ford case, you'll see it in there. There's a discussion about it. Also, you can also read Common Cause Indiana versus Lawson. That's 937 F3rd 944, and that also talks about individualized inquiries in that case. So there's some. If you want to go read those cases, we can discuss them.
Is there any further discussion with respect to probable cause? Or at least the motion that's on the table, inasmuch that Ms. Fisher has made a motion to find that there is probable cause to move forward with a hearing, because this would not be the removal. This is correct, Mr.? This is
Just
finding
probable
this is finding probable cause such that you then could move forward with hearing.
Yes.
So that's the motion on the table. It's been moved and properly seconded. There's been robust discussion. I think we can go ahead and call the question. All of those in favor of the motion such that there is a finding of probable cause as it relates to these 13 active voters that have been challenged indicate as much, yes. All of those that do not find that there is probable cause, your vote in nay. So the
I
motion,
just want to clarify.
Yes.
I just want to make sure. Her motion was to find probable cause, so it's just saying.
we didn't find
you're-
probable cause.
You're just saying you're not approving her motion to find probable cause, so
That's correct.
the motion doesn't really say the inverse. You might want to have a motion that does say the actual inverse and consider a motion that there isn't a probable cause.
Okay, understood. So to be clear, nay votes were to indicate that there was not a finding of probable cause with respect to, holding a hearing on the 13 individuals or 13 electors that are listed as active on the August 26th challenge. So that motion fails. Is there a motion that anyone wants to put forth?
I will move to dismiss the challenge based upon the NVRA 90-day rule, as well as our filing requirement policy regarding this, section D, number 4. So,
And that's a finding, not finding probable cause.
that there is not probable cause to move forward with this challenge.
Okay. Is there a second?
Second.
It's been moved and properly seconded that there is not a finding of probable cause to allow us to move forward with setting a hearing on the challenge of these 13 active voters from that August 26th challenge. Is there any discussion?
I'll just comment that the data submitted looks like it's credible. On the other hand, we're within the 90-day limit of the MVRA, according to Daniel. So I'm voting for this motion to not find probable cause because of the 90-day limit.
That is why there was robust conversation about the 90-day, and I do want to put it on record. I would like another legal opinion on this because I do not agree whatsoever with the interpretation of legal counsel's 90-day rule.
Well, thank you. That's duly noted. You got that in the notes, Ms. Everett? Perfect.
I just want to add that we do actually have additional legal guidance from the U.S. Department of Justice that just came out regarding that. So that is additional legal opinion and advice regarding this specific.
Again, that's an interpretation. I'd rather have somebody live take a look at exactly what has just been presented and give us a written legal opinion.
Okay. And when you say what has just been presented, are you referring to the statements that Mr. White made in connection with the documents that Mr. Williams provided that appears to take information from the Georgia Secretary of State website and merge it with the Florida Secretary of State website and then maybe compound it with the USPS NCOA information, and it's all in one document, and I don't see a source. Is that the same information you're referring to?
No, I'm referring to his legal opinion on the 90-day restriction.
Okay. Got it. You got that? Perfect. There is a motion on the table, unless if there is any further discussion. There's a motion on the table such that there will be a finding that there is not probable cause to move forward with setting a hearing on these particular challenges. So we'll go ahead and call a question. All those in favor of a finding of no probable cause? Those that are not in favor of a finding of no probable cause? And so we'll note that the motion passes 4-1, noting that Mrs. Fisher, Board Member Fisher, voted in the negative. Okay. All right, moving on to the next one. Mrs. Fall, you're up. The August 28th voter challenge?
Sure. So this was a 230 challenge based on voters who are registered in Florida. And it was appeared to be matched with their voter registration information from Cobb County. So it was a total of 2,939 voters. Of those, 176 are active. One thing I thought was interesting in talking with the team about this challenge in particular was that the reason that we see, I think, a lot of challenges come from Florida is because they're very strict about the information they release to other election offices. So, for example, if we get a notice that someone may be registered in a state like South Carolina, right, or Tennessee, our office will call that county and they will ask them for their voter registration form in that county, and then they'll match that information, and since that has a signature on it, they'll use that to make sure that's the right voter in Cobb, and they'll use that as a voter cancellation. So that's why we don't see a lot of challenges from other states, is because our office takes the extra step to do that. However, Florida does not legally allow their offices to release those voter registrations. So we cannot use that signature that was on that voter registration form. So I just think that that's an interesting thing to know about, I think, why we see a lot from Florida is that their restrictions on what they can release to other jurisdictions happen to be quite strict in relation to the other states we typically work with. So thought that was a fun fact for everyone.
Okay, thank you. Does anyone have any questions for Mrs. Fall with respect to the information she's provided to us on the August 29th challenge?
Seems like for consistency, we would take the same action that we did on the August 26th challenge.
Yeah, we do have to take a vote on it, per Mr. White, correct?
Yes.
Okay.
All right.
So is there a motion?
Yes, I will move to dismiss the August 29th challenge because it falls within the 90-day policy.
So this is a probable cause determination, so we need to have a motion
Oh, sorry.
that, that we did not find probable
Okay,
cause.
I motion that we did not find probable cause in the August 29th challenge.
Okay. Is there a second?
Second.
It's been moved and properly seconded. Is there any discussion? Hearing none, we'll call the question. All of those in favor of approving the motion wherein we did not find probable cause, if you'll vote as much. Those that are not in favor of the motion, not finding probable cause, the motion passes 4-1, noting that Board Member Fisher voted nay. All right. So the next item on the agenda is the item that we added at the outset of this meeting. On Friday, we received a voter challenge also under Section 230, asserting a challenge to the ability of 11 voters to vote in this upcoming election. Mrs. Fall?
Sure. So this was, like you said, a 230 challenge with information based on homestead exemptions. There were 11 voters in this challenge, and they are all inactive.
Okay. I don't know that there really needs to be a motion, Mr. White, in as much that we didn't take a motion, or we didn't entertain a motion with regard to the inactive voters for the previous two.
Yeah, that's correct. I mean, this one's really just on here to note that it runs afoul of the restrictions in OCGA 21.2235 that says that an elector placed on the inactive list of electors shall remain on such list until the day after the second November general election held after the elector is placed on the inactive list of electors. So there was a request by a citizen earlier about the basis behind not removing voters from the inactive list of electors. That's the language that the Georgia legislature adopted, and I want to note that at the bottom of that statute, it draws a distinction very specifically between, it says that there's a list of official list of electors that's provided at the polling place, and there's also an inactive list of electors that's a polling place, and that's because, as we discussed in prior meetings, that there is an official list of electors that are used for things like names of number of ballots have to be printed and all those kind of things. And inactive electors don't go towards that. And that's because inactive electors are sort of presumptively ineligible. And so that's a separate list. Once they get to this point where they have mail returned from a notice that was sent, or they have no contact for a couple of cycles, then they end up on the inactive list. And this is 235 is Georgia's adoption, basically, of the standards under the NVRA, or their way of implementing it. It doesn't have to mirror the exact language, and Georgia has taken, the legislature took the opportunity to say that an elector placed on that inactive list shall remain on the list until the second, basically after the second general election, once they get placed on there. So that's been read by our county and adopted into its policies, and other counties in Georgia have also adopted a similar policy saying that once an elector's list on the inactive list, they're not to be removed unless they confirm it. There's a couple of other exceptions where if they confirm it in writing, and that comes from the registrant, then they can be removed from the inactive list that way. So that's just, it's on the agenda tonight because, normally you would sort of consider it for probable cause at your first determination, but because it runs afoul of 21-235 and the board's policies as adopted, we just needed it on there to note that those were going to be, under the policies, just rejected with a notice sent for why they were rejected.
Okay, sounds good. Does anyone have any questions before we move on to the next item on the agenda? Okay. Hearing none, we are next going to consider a resolution of this board, and I will turn it over to you, Ms. Hefford.
As most of us know, Gabriel had issued a statement in the last few weeks.
August the 21st.
I'm sorry, what?
August the 21st.
August 21st, thank you. Saying that the new rules made by the state election board puts our election integrity at risk, and they ask that new rules are not added and implemented within 90 days of the election. We agree with Gabriel's statement, and I suggested that our board issue a resolution saying something similar, because our focus is running a smooth election as accurately as possible, and introducing any new rules this late in the game adds risk to that process. We're working on getting this shown on the screen. There you go. I don't know that I need to read word for word, but
No,
everyone can
I
read
will
it.
note, however, that Mr. White did send a non-substantively further revised version such that, and I can let him go through it, that allows for, it's a slight modification than what's presented here. Mr. White?
No, the only thing that changed in my version is that instead of it being proposed, I think I sent one out either this morning or this afternoon that just took the proposed language off there and basically bolded the title, the proposed resolution. That language there before all the whereases is bolded as the title of the resolution, and then some on the next page, some signature, like a date and some signature lines were added. And I thought I was digging through my file folder back there because I thought I brought copies, but I'm now thinking they're sitting on my copier at the office, but I did email those. But everything in the whereas clauses and all the resolve, that's all stays the same.
Right. And you emailed that to the entire board, correct?
Yes.
Okay.
Yeah, the whole board has been going back and forth via email, weighing in with feedback, and we've tried to incorporate as much of the feedback as possible. And Mr. White has given us his legal approval that this is sound, and so I move that the board votes on issuing this resolution.
There's a motion on the floor to adopt this proposed resolution. Is there a second? Okay. It's been moved and properly seconded to adopt the resolution. Discussion?
Madam Chair, I do ask that Member Mosbacher recuse herself from this, considering the fact she's a plaintiff in a lawsuit filed against the rules made under certification that is, I think, a serious conflict of interest, and I would ask she recuse herself.
Okay. Thank you for that. Mr. White, do you want to weigh in on that?
Yeah, I don't mind weighing in on that.
Thank you.
conflict of interest rules generally at these, and on these type of things are really talking about financial and sort of relational, like are you related to somebody that has a financial interest in terms of public bodies and not voting on things, or do you have a direct financial interest? That's not what we have here. I do note, just in terms of distinctions, I think, and it's probably a good place to address this because there was a comment made at the beginning. This resolution I don't believe it has anything to do with the laws that were, or the rules that were already passed. I think this resolution, the way I read it, was to say that they don't want additional rules adopted and implemented going forward. And there's no suggestion anywhere in here that the board not implement rules that are passed. It's just asking for a 90-day break before elections in the future, and presumably for this one as well. So I don't see a direct conflict where she couldn't vote, but it's up to Ms. Mosbacher if she wants to participate in the vote or not.
Would you consider it the appearance of impropriety?
No, I think this is a, I don't think so. I mean, she's not, doesn't appear to, I've reviewed the lawsuit that she's joined, and I don't think it's directly related to the rules that are challenged in that lawsuit, but the appearance of impropriety is kind of a very mushy standard on purpose, so just that it's really up to the board member to decide whether that's the perception they're giving.
Okay. Thank you for that, Mr. White. And I also will note, while it's not my habit to read to adults, I will note that the first resolved provision reads as follows. Resolved that the Cobb County Board of Elections and Registration stands with Gabrielle and urges the SEB to halt the implementation and adoption of additional election rules that would go into effect for the November 2024 general election. And so, given the context in which this has been proposed, my understanding of this, what we're resolving, is that it does apply to future rules, not rules that have yet been, or that were previously adopted, in as much that we are currently complying with one of them, having set the pre-certification meeting for November the 8th. Is there anything further? Nope. Okay, the motion that is on the table is for the board to adopt this resolution. So all those in favor of the adoption of this resolution, if you'll say, indicate as much. And the motion passes unanimously. Glad to see that. Mr. White, when you shared the slightly revised version, you posed a question to us with respect to who the signatories should be. I believe you initially suggested that it might be myself as chair and Ms. Everett, not as the proponent of the resolution, but as the secretary. But then you also indicated that there is potentially a path to have all 5 of us sign it.
Yeah, the typical resolution that you might see at a board meeting or a council meeting would usually just be signed by the chair and then attested by either the secretary or, like, if there's a clerk, a county clerk, that might be who witnesses it. But if there's no clerk that regularly attends, then you would have, like, the secretary attest. So I originally prepared it that way, just as I would do most. But there are resolutions, just like the 489 resolutions that were passed recently, those were signed by all the council members or board members. So it's just a resolution, so there's no, and especially this one, this is just calling for a policy to be implemented. So there's no specific format that it has to take. So if the board wants it prepared where everybody signs it, and that's absolutely something that can be done, or you could just do it in sort of the standard chair signs with an attestation.
Okay. Well, in light of the fact that the resolution was adopted unanimously, unless there is objection, perhaps it makes the most sense for all 5 of us to sign it, because it did pass unanimously. Okay. Mr. White, if you'll prepare a revised version, and we will, I presume we can sign that electronically?
Sure, I'll circulate it.
Okay, excellent, thank you. The next item on the agenda are our amended and restated bylaws, something that I've been talking about for a while. So amended and restated bylaws. The bylaws that we are currently operating under are the bylaws as adopted when this board came into existence. I want to say it's either 1981 or 1984. Obviously, lots of things have changed in the world, and I thought it necessary for us to amend and restate the bylaws. All that being said, I've heard from the balance of the board indicating that because we are so close to an election and we have a number of other pressing items to consider, that we would table the consideration of the amended and restated bylaws until after the election. I believe, Mr. Bruning, you suggested January?
Yes, ma'am.
Okay. So I will entertain that motion to table this agenda item until January.
I move to table the bylaws discussion until January.
Is there a second?
Second.
It's been moved and properly seconded to table the bylaws to discussion until January. Is there any discussion? I actually do have a question. Mr. White, during the course of, obviously, us emailing among each other about the decision to table this, there's been considerable, I guess, positions advanced that if a provision in the bylaws cannot be tied back to a specific provision in the election code, that that provision should be removed. And so I know that we are tabling the bylaws discussion, but when the matter does come back up for us to discuss the bylaws, I'd like for a legally compliant version to be presented. So if you will, just briefly, sir, provide us with your position as to whether every provision that is set forth in the bylaws must be tied to a specific provision in the election code.
And I don't recall seeing that email, but just based on your question that you're asking, I know that's not, I mean, every bylaws would have the basic function of the bylaws is really to set up your process for electing, or, secretary and different positions like that, and for how you would call a meeting and how you, but I will say most of that is, indirectly set out in the enabling legislation and the subsequent amendments. So a lot of it is going to tie to enabling legislation, and there will be other items that may reference directly the Georgia election statute, but the enabling legislation gives you the authority as a board to adopt your own bylaws, and a lot of that's just sort of adopting the standard Robert's Rules type provisions, and some of those have discretion around when you would do elections for office, or nominations for, secretary or for those other things, or when how many people are required, under the, as an example, under the enabling legislation, the chair or a majority of board members can call for a board meeting, but there are some other things you could add procedurally to that aren't necessarily directly in the enabling legislation. So most of it's going to tie to the enabling legislation or to election law, but it doesn't all have to come from directly from a statute or from the enabling legislation.
Okay. Just wanted to be certain, because perhaps there is a tad bit of pride of authorship, but having drafted them and put considerable time and energy into them, especially given kind of this dual reporting structure that our election director has, reporting to this board, but also reporting up through Dr. Jatun Gibson and up through to Dr. McMorris, it seemed prudent to provide some guidance in the bylaws. So I probably won't revise them prior to us giving the guidance, prior to us taking them up in January. But that's what's on the table, to table the consideration of the bylaws until January. So all of those in favor? And the motion passes unanimously. Thank you very much. Next up, you're up, Mrs. Fall.
Awesome. Well, we'll get some slides up, and I'm just going to give an overview of kind of the work that's being done at the moment to prepare for November, and just provide some key numbers and some key dates as reminders. We are 50 days away from the election, and it's here. So flew up to Northern Virginia over the weekend for a conference, and I got to see some of my old colleagues in Arlington, and they start early voting Friday. So it could always be worse. So I think that's nice to have a little perspective there. So I wanted to start off by going over where we're at with some of our equipment orders. We're very gracious to our Board of Commissioners for approving our contingency budget. A large portion of that is the things you see on the screen here, some more equipment for us. So we've already received our pallets from Dominion, so 20 new scanners, which will be great to help to have backups and to have enough to cover the additional AIP site, as well as 20 ATI kits. Those are those tactile keypads and headphones that we use to make those ICPs ADA accessible. And so we just see the wear and tear on those, especially from AIP, because they're actually used a good bit. We wanted to make sure that we have enough to make sure every single polling place has either a fresh or a functional ATI kit. And then from No Ink, we have ordered 100 encoders, which are shipped. So those are the encoders that go into the poll pad that encode the voter card that goes into the machine. We always have issues where they get loose and then they can break. And so what's great is that since we're ordering poll pad printers for all of our poll pads, they come with a bracket that helps that encoder be more stable. So the big order on here is the 543 poll pad printers. That'll significantly help decrease wait times on election day, as voters will no longer have to hand fill out those voter certificates that you guys love doing. And now, since you're already signing that poll pad screen that says that same voter certificate, they immediately get printed out and then they're held for records. So they come back just like they do in AIP. They're scanned in and associated to your voter record in our system, and then we don't have to sit and fill out any more voter certificates. So we're really looking forward to that. So we should have an ETA on the shipment for those hopefully by the end of the week. And then we'll work with Secretary of State's CES office to come over and get all of those acceptance tested. Luckily, the printers are pretty quick, so we should be able to knock out the 543 printers as well as the 13 additional poll pad sets within a week, is what their estimation was. So we're looking forward to that. We have settled on our logic and accuracy testing schedule, so we are advertising this in the legal organ, and we'll make sure that this is updated on the website. So our in-person voting units and tabulation scanners will start on 9 a.m. on Monday, September 23rd, and that's at 30 Key Drive. That's that small warehouse that's just across from our office. We do all of the AIP equipment over there, so that's why that's at Key Drive. And so that'll be from September 23rd until Tuesday, October 1st is our estimated completion date for the AIP equipment. And then we'll move back to our regular office, 995 Roswell, on 9 a.m. Tuesday, October 1st for all the election day equipment, and we'll do that every day until completion. So all of those days are open to the public to come and observe. You learn a lot observing when you do LNA, and so I think it's a really cool opportunity. And then our ICC, our absentee by mail high-speed scanners, those will be LNA'd 9 a.m. on September 30th at our office in that ABM area. So we'll test all of those and get them all ready for Election Day and early tabulation. Let's see. Okay, so here's some current numbers that we have. So I checked these this morning. So our numbers have declined. As y'all know, you see them every Friday. So the team has been working on Saturdays to try and get some of our key numbers down. So as of this morning, we had 8,772 records from DDS to key that could be new or updates. The online voter registration apps are just over 5,000 as of this morning. And MVP updates, that's at 1,993 as of that morning. So that could be updates, that could be a request to cancel, that could be a move within the state or within the county. So lots of different options there. The DDS number was over 10,000 on Friday, so the staff really worked hard. It's nice to come in on Saturdays before AIP starts because the phones aren't ringing, and so they're able to really get their heads down and just do some keying and auditing. So that's we're really grateful for that, and they'll be there this Saturday too. Our voter registration deadline is October 7th, so make sure that any updates that you have, any new registrations are in by that date. And then I did want to take a moment to talk about the voter cancellation request process. As many of you know, the Secretary of State launched a new portal option where voters could submit online the option to request their voter cancellation. So last week I provided 2 files to y'all. One is the procedure for deleting electors moved out of state, deceased, or felons. That's the process we've had in place. And then our additional guidance in internal procedure on the MVP voter changes. And then today, under your agenda packets, I provided the Secretary of State guidance that was given to us. And so whenever we have voter cancellations, whether it's from the voter in a letter form or returned mailing or it's in the portal, that is a request from the voter to be removed, right? So we still have to key that. It's not automatic. So typically, that first procedure lays out what we do when we get that ERIC mailing back or when we get a letter requesting to be removed. So we have a process where we search, we identify the voter, we match based on different information that's been provided, and then we go through the process to remove that voter if that information matches. There's lots of different opportunities to hand that over to a supervisor based on the evidence that's provided and all the evidence that we keep. And so that's kind of the historical process we've had based on the traditional letters that we've gotten. And then the new procedure is what we'd like to move forward with the cancellation requests that are coming from Jarvis. So they're all in that tile. You can see there's a little screenshot of what that tile looks like. The MVP voter changes awaiting review. And then the list of awaiting voter review, that'll give you the number of records that are to be processed, which as you can see are 1,993 as of this morning. They'll look for those voters' name and then they'll enter the driver's license number. And then once the voter is found, they can see that image below, that Jarvis voter record versus the cancellation form. So in order for that voter to submit that information on the portal to request a cancellation, they have to provide either their driver's license number or the last 4 of their social security number, and they have to have a signature on file with DDS. Because we have to have that signature, kind of like I mentioned earlier, we have to have that Florida voter registration form with a signature in order to remove a voter. It's the same for a voter request to be removed, we have to have a signature. So if they don't have a signature on record with DDS, they can't submit through the portal. They have to submit a regular traditional request. And that's because it pulls that signature into this letter template that you see here, and that's how we have that signature on file. So it puts together that cancellation letter, and then we make sure the information matches, that it's associated to the right voter registration, and then it walks you through the steps on how to actually confirm that cancellation that the voter has requested, as well as how we keep all of that record for that voter registration record to have on hand within the required years of retention. We talk about if there's any questions about any type of discrepancies, go to your supervisor and then move on to the next voter on the list. So we have policies that have been laid out here. You'll notice it's very similar to the guidelines provided by the Secretary of State. We also received guidelines, kind of an internal process from one of our neighboring counties that's almost identical to our process that we have here. It's actually a little bit more broad. We have a little bit more specificity in our SOP that we're proposing for those MVP cancellations.
Okay. I have questions, but does anyone have any questions about, go ahead.
We might have the same question.
Yeah.
I've heard in the news that they're worried about the risk of a voter being canceled, not because they did it themselves, but because there was a bad actor trying to go out and cancel other people's registrations. And since we're not requiring the person requesting the cancellation to provide a signature that we can match to, as long as they have a driver's license number or the last 4 of the social, what's the protection to the voter if they are a victim of someone trying to do it on their behalf?
This is a great question. This was brought up at the Secretary of State training. Unfortunately, we didn't have the opportunity to ask questions at that training, so that would have been a question that was asked. But they did touch on this a little bit, that they are tracking the IP addresses of those, of when these are submitted, so they can see if there's an IP address that's submitting multiple, or if a voter did say, hey, I did not request to have my voter registration removed, then an investigation would be opened by an SCB investigator, the Secretary of State investigators that we all know and love, and they would investigate kind of that claim.
So to follow up on that, if, let's say someone tried to cancel my registration after October 7th, which is after the deadline to register for the November election, would my registration be canceled immediately and I'd no longer be able to vote in November?
Once it's keyed, we still remove voters after the voter registration deadline. So the books don't close per se. We still process cancellations that are requested, yes.
So we can cancel at any time, but you can't register at any time.
Right. I think in that scenario, if you showed up on election day, you would vote provisionally, right? And then you could provide supplemental documentation, and then it would be up to you as a board to decide if you're going to approve that provisional ballot or not.
Well, I guess we were going to ask very similar questions. I have the same concern, in as much that there very well could be bad actors, and I did participate in the initial training, the webinar that the Secretary of State hosted, and I did hear conversation about the IP address, but if I decide I don't believe that Ms. Effrett should vote, you're not going to catch my IP address because I'm only canceling her registration. Or if I decide I want to cancel my ex-husband's registration, I'm more likely to have his social security number, or the last four, his driver's license number, or and his date of birth. So I guess my concern with this is the same concern that I shared with you when I reached out and asked you to provide this information to us. Are we doing any secondary follow-up when a cancellation comes through this portal to confirm that, yes, Ms. Effrett or my ex-husband actually submitted that and it wasn't from a third party?
We don't do any confirmation prior to what's provided to us. So if that information matches, if you have that DDS signature on file and the birth date, the last four provided, or the driver's license number provided, as long as those records match, that voter registration would be canceled, and then we send a letter. So the last step in any cancellation is always mailed a letter. The voter is mailed a letter letting them know that their request to cancel their voter registration had been approved and had been completed.
Okay, so while not secondary like a secondary check, it's still confirmation, such that when Ms. Effrett gets notice that I canceled her registration, she minimally will take a look at it and say, no, actually, I didn't submit this.
Correct.
Okay. Are we flagging cancellations that are coming through the portal versus those that are, is there any way to draw a line of kind of distinction, those that come through our traditional process, the letter or the form that you shared, versus through the cancellation portal?
Yes, I believe the ones coming through the portal are in a separate tile. The ones that we get by letter would be keyed in manually. And then I believe the audit trail would show a distinction between an MVP request, because it says MVP, and then a manual request. So we would have that on that audit trail of that voter registration, of their actual voter registration record. That would show whether that request came through MVP or whether it was a just cancellation request. We say requested is the reason.
And the MVP designation, is that something that's readily available to you all? Like if I asked for a listing of the number, not individuals, because I don't need to know names, but the number of cancellations that have taken place, and of those, how many came through MVP versus how many came through our standard, or the standard process, is that something that you could readily and easily provide to us?
I think we could do a report on that. We haven't moved forward on any cancellations that have come through the portal yet. We wanted to wait to present this procedure to y'all before we move forward with that.
Sure.
But we could do a report that showed that recent activity change.
Okay. All right, we can talk more about that report. I know obviously you provide your weekly report. I don't know if anyone else has questions about this, but I personally would like to see the, the distinction, a total number of cancellations on whatever periodic basis, whether it's weekly or biweekly, and then of those cancellations, how many are coming through this portal and noted as MVP versus those that are manually keyed, because your team receives the form.
Great.
I just have a few thoughts on this particular issue. I definitely, first of all, I have a lot of concern about this portal. So my first question is, and maybe Melissa can answer this too, is, was this something that was requested by Gavrio professionals or you all, or was this something that was beta tested? Like, did you know this was rolling out? Because it's like, it seemed to me it just sort of came out of the blue in a very, contentious time in a crazy election period. Like, I have a lot of concerns about how this portal rolled out.
I think prior to my long tenure of 10 months, in those 10 months, it was not something that we had discussed at all. And I don't believe it had been previously brought up at other Gavrio meetings or Gavrio conferences. And then I know for a fact, up until the rollout of the system, that we had no idea about it ahead of time, that we just got an email saying that actually we saw the press release that there was a portal, and then we got an email about 2 hours later.
So do you know if were there any counties that were a part of a beta test with this? Was there any?
Anytime they roll out an update to Jarvis, there is a group of special Jarvis users that some are anywhere between 8 and 20 different counties where they roll things out, and if there's an issue, they'll be the ones that go in and help the actual Salesforce professionals fix that system. I'm not sure. I would hope to assume that same process was followed for this, but I have to ask my Gavrio colleagues to see if that same user group was utilized.
In the past, there is no, I just want to, I know the answer to this, but I want to say this publicly. It is not like a password protected, like, third-party authentication. There is no requirement to get into this cancellation portal. It's just like logging into MVP, correct?
Correct. It's the same frame of login. Yes. So first initial of your first name, last name, your county, and your date of birth. And then in order to process that application, in order to actually be able to hit submit, you have to have a DDS signature on record, and you have to provide either the last 4 of the social or the driver's license number.
And then once that voter is canceled, they walk into a poll, and there is no record of that voter in the poll pad.
Right, it wouldn't be in the poll pad because they'd be removed, so they'd call us. We would be able to pull it up, see what the issue was, and we would advise that precinct to allow that person to vote provisionally.
I am just going to say, for me personally, I am very uncomfortable with the way this was rolled out and without there being some form of actual contact with a voter before we cancel them, or voters having the option to opt out of cancellation. Like, if I could log in to my MVP portal securely and say, no, I don't want any electronic cancellation, that would be one thing. But right now, I think in today's, I don't know, I assume probably many people in this room, there have been data breaches left and right in all different kinds of banks, AT&T, huge data breaches. I get a notification 6 times a week about my information being found on the dark web. I think that as far as I'm concerned, I would, if we are allowed to freeze cancellation portal cancellations with no other, if we can just say we're not going to do that right now, that would be my preference. We're just too close to the election and there's just not enough verification. That's me personally.
Well, no, that's the conversation that Ms. Fall and I had. I asked her, don't process them
Right.
Until she could come and provide this update to us, because I, like you, had significant concern. When it was rolled out, it looked exactly like MVP. It was during that webinar that flag was raised, and they subsequently changed the color of it, but it really does, whereas MVP, the border is blue and green, this one's red and blue. It looks exactly like MVP.
Right, and there's no password protection to log in, right? So, it's like we have all these steps, think about what's involved in just applying for an absentee ballot. It's like we have all these safeguards, all these steps along the way, and then for this, we have nothing.
All right, and to be certain, this digital signature, it would be whether I, Tori Silas, whether I have a digital signature on. It has nothing to do with the person that I'm canceling. It's not Ms. Effort's digital signature, correct?
That's correct. And if you, I don't know if there's an image in this, but on the, I don't think there is, on the home screen of where you log in, where you can log into the voter registration cancellation portal, there's actually a bolded note that talks about if you're canceling a voter registration for a loved one who's passed away. So they acknowledge that others could be submitting that request. The thing about that is that MVP cancellation isn't gonna show, the reason we put in there for the reason they're canceled is request, not death. And so that's kind of something that'll be a little funky if people do go in and, you know, you're conscious of that, you have a parent or a grandparent that passes away and you do that for them, but it's not gonna show they were removed due to death, it's gonna show they were removed due to a request. And there's no way that I'm gonna know that it was that individual, right? I'm not aware that they passed away, so I don't know that it was their child or their spouse or whoever.
I'm sorry. So there are three options, if I recall correctly. Death being one of them, moved out of state, moved to another jurisdiction in state. And that would be, that in and of itself isn't a cancellation, that would just be an update of an address. But setting that aside, if I am canceling, I'm a loved one, my loved one has passed away, I'm canceling there's no indication, there's no reporting that says that I canceled my great-grandmother's registration because she passed? It's just listed as a
Right, it just says,
cancellation?
I think it says if you are submitting this form on behalf of a loved one, please enter their information, not your own.
Yeah, I
Because then
see
you'd
it
be-
here.
You'd be canceling your own voter registration if you did that, so.
Right, but I would tend
There's
to think,
no.
but when you get past this, I know you click, it's because the person is deceased, but they're not tracking that information such that when you go back and take a look at it, you can run a report and it's people that are deceased?
We'll have to look and see what the report looks like on our end once it's actually been pulled through. In the traditional audit, it would just show MVP update.
Okay. How many, and if you don't have that number now, it's fine. I note the hour and we're at the conclusion of our meeting. However, this is extremely important to the extent that individuals could be canceled now or even after voter registration day and don't have the ability to register or to vote. How many current MVP cancellation requests coming out of this portal are we sitting on, if you will?
I don't have that number in 150, 150.
And how many cancellations do we normally process generally?
Well, after an ERIC mail out, we normally get a good bit.
Okay.
So I think we're in flux because of that right now.
Okay.
Outside of a normal list maintenance process, not very often.
Okay. All righty. I think I personally have beat this up enough. But
I just have a question, because Jennifer's comment made me think of it. Do we, as a county board, have any right to put a freeze on this? Or are we legally required to go with what the Secretary of State is telling us to do?
Yeah, I mean, I think you're preempted to the extent this is a Secretary of State, this is a state level initiative. I think it has to be
So we
uniform.
can't put a freeze on it?
Not that I mean, I'd have to look at the information behind, but my initial thought is no, but I can look at it if you want me to.
But we can add an additional step. Sorry.
Like asking the voter to confirm
Before it's keyed.
that would be great.
And there was some conversation during that initial webinar about that. So I was surprised that when this came out from the Secretary of State's office, that it did not include that, because I recall that being a part of those discussions, so. Continue to press pause. Not to suggest that we're not going to do it, but we just wanted to vet it a bit more. We will comply, obviously, as necessary.
We can handle that.
Okay.
Can I ask one more question?
Sure.
I'm really concerned about someone getting canceled after the voter registration deadline, and then there's no other option for them to vote other than provisional, but can we create some kind of like form, like online, where they can fill out saying, I was canceled, but I don't want to be, like, this is my appeal, or whatever, if it happens after the voter registration deadline, so we can actually have documentation that they tried to undo their cancellation, and then that will help us if they vote provisionally to say, yes, this person has already shown us that they did not want to be canceled.
I can get with the team. I'm thinking that a lot of people probably wouldn't know till they showed up to vote.
Right.
So what we could do is work on a form for our provisional clerks that could be included with that provisional ballot, stating that, and maybe where they can fill in their information. Just so that way when it comes to the registration team, they know what to look for. So we can look on that. So I think that that might be a way that we could do something like that. That way it's noted exactly why.
And also, if they do receive the letter and they read it and everything, maybe the letter can indicate what they can do to undo their cancellation.
Yeah, post-voter registration, yeah. I'll get with the registration team tomorrow, and we can look at what that might look like for us.
Mr.
And
Bernie?
from a training perspective, we probably need to make sure that something, we have those, all the codes that we use for provisionals.
Yeah.
We either need a provisional code that identifies portal cancellation, or I don't know if we have time to change all the forms. We certainly need to make sure that training for the provisional team understands this probably needs to be flagged separately.
Absolutely, and we can make sure that's highlighted in the last minute instructions, which is
Yeah.
what everyone looks at. And so we'll know that after we can implement that into training, that it'll be, whatever change we implement would be highlighted there. That way the provisional clerks are prepared.
Right, and then the audit teams need to know too, probably, right?
Absolutely.
So, all right.
And that's
Sorry,
why
that was
it's
technical.
important for us to be able to have that distinction between those that are counseled per the standard or the manual process versus those that are counseled per MVP. Mr. Bruni?
I think I heard you say that you thought there were 150 voters that have requested through this portal. Can't we just mail them a letter asking them to confirm?
We can surely do that if that's what
Yeah,
the
well,
board would
and
like
that-
to do.
But not now because of NVRA, right? Like that's.
I think that the difference here is that this is a request
Request.
from the voters. So NVRA does allow requests from the voters to be accepted during the 90-day period.
It
That's the
does.
reason that this is allowed, like, the Secretary of State's interpreting it, that this is a voter request with a signature.
Okay.
And so that's why it's allowed to go up, it's allowed to go past the 90-day, and really up until, inside the 45, this is not considered list submission, there's NVRA and state law both say, a voter requesting to have their,
Technically, that's individualized.
well, it's not
That's
even
the-
just individualized, it's just at any time, a voter can request to have their,
Okay.
and so the Secretary.
I just want to
of State-
make sure that if we're
Right.
sending something to a voter, that we're in compliance.
Because it would be you, we have received a request from you to be removed from Cobb
Okay.
County's voter roll, not, it's a notice of a challenge, or it's a little bit different. It's saying, we've received a request from you. If you did not submit this request, please call us or let us know.
Right. And it's set forth here. However, the 90-day deadline does not preclude removal of a registrant's name at the request of that registrant. So if we're simply confirming that what was presented to us to be a request of the registrant, we're simply confirming that. I don't see how that is
Perfect.
violative of this.
So, yeah, then let's definitely do
We can,
that.
we'll work on that, and I'll send it, Chair Silas, to you for approval, like I normally do with the letters, and then we can go from there.
Okay. Ms. Fisher, did you have something? You're not on, that's what it says.
I was just going to ask if we could move forward because we do have executive today.
Understood.
So
Yep, this is extremely important.
it
And-
is
Yeah,
important.
and I think we've
but
reached
I think we've-
resolution.
Yeah, okay.
Okay. So the next item on the agenda, I believe we've made a conscious decision to move up I'm sorry, did you have anything further?
Just 2 more slides.
Okay, go right ahead.
So first is absentee by mail applications. We have received a lot of absentee by mail applications. So as of this morning, we received 17,816 applications. 900 were in further review when I checked at that time. 7,045 have been accepted. 1,207 are UOCAVAs, and 4,069 of those accepted are rollovers. The UOCAVA ballot mail-out deadline is this Saturday, so we'll be mailing out those ballots. Most of them get emailed. We still mail a handful of those by Saturday, so we're excited to see those go out the door. And then the regular ballot mail-out date is the same date as the voter registration deadline. That's October 7th. So that's when we'll start seeing regular ballots hit the mail. And then I just wanted to end with this. These are upcoming key dates and deadlines. So like I mentioned, Uocava ballot mail-out date is this Saturday. Regular ballot mail-out, October 7th. Voter registration deadline is also October 7th. First day of AIP is Tuesday, October 15th, due to the Monday Columbus Day holiday. The last day of AIP will be Friday, November 1st. And then, of course, Election Day is Tuesday, November 5th.
Okay, thank you, Mrs. Fall. I think we've pretty much exhausted all of the topics perhaps to ask her questions of, and I do agree with Ms. Fisher, we do need to move along. But I do appreciate the questions and the suggestions with regard to the portal because we've all had concerns about it. I have no updates to provide, and as I was saying, we were conscious in moving up board member comments, but I again do note that there are matters, Mr. White, that we need to discuss in executive session, correct?
Yes, I think we need to do both pending litigation and potential, well, just litigation, because there's pending and potential, and then also, I think there's a need for some short personnel.
Personnel matter, okay,
Matter as well.
got it. Any board member comments?
I do have a comment.
Go right ahead.
I've received several questions in the last week since our meeting asking why I recused myself from voting on the adjournment. It was a real dilemma for me because I wasn't in favor of adjourning, nor did I want to vote no, because most likely it would be construed as me not having a problem with the hateful comments that were made during that meeting, which is why I recused myself for the curious minds. I have, if it were me, I would have called a recess, allowed people time to calm down, and given the opportunity for the guy that's yelled out to be able to leave the meeting room with all the people rather than asking him to perp walk outside the room. When we reconvened, it would have been easy for us to obviously point out who didn't come back after the break. Instead, here we are today, 2 hours and 10 minutes doing the business that should have been done last week, all due to the hateful rhetoric that was presented in that meeting. With hateful comments being top of mind, I want to address what happened yesterday in the second attempt to take the 45th president's life. Just days before the first assassination, President Joe Biden made this statement to donors: "It's time to put Trump in the bullseye." While this statement was taken totally out of context from people on my side of the aisle, words have different meanings to different people, especially when coming from elected officials. It could be seen by some radicals as a call to action. Vice President Harris and her surrogates have repeatedly claimed that former President Trump is a total threat to our democracy, calling him a dictator, comparing him to Hitler, repeating false claims that he's a white supremacist, when in fact that's been debunked by every fact checker in the country. And there are other despicable names they've called out time and time again. A Democrat congressman even posted on social media after the first assassination attempt that next time, make sure you don't miss. Another one suggested that the shooter should have taken shooting lessons. Where is the outrage over that hate speech? Instead of toning down rhetoric like both sides promised to do, it's been ratcheted up. Our last meeting was disrupted due to the same kind of hateful, unacceptable vitriol. Chairman Cupid came out this past week with a public statement, rightfully condemning the commenter who shouted, "Heil Hitler." However, she completely ignored her own board members' comments made in the work session that week. And she said nothing about that commissioner calling the people in attendance J6ers, election deniers, and went as far as saying that we were worse than the Crips and the Bloods. This was an elected official's comments, not some rogue, radical, insensitive who spewed the hate speech in our meeting. This type of vitriol, especially from elected officials, is never okay. No matter which side it's coming from, it needs to stop before someone ends up getting badly injured or killed. And I would ask everyone to always try to be respectful.
Thank you, Ms. Fisher. Unless there are further board member comments, I believe, based upon Mr. White sharing with us, that there is a need to move into executive session for the purposes of discussing a personnel matter as well as current litigation. We'll entertain a motion to move into executive session for those purposes.
So moved.
Thank you, Mr. Bruning. Is there a second?
Second.
It's been moved and properly seconded to move into executive session for the purposes of discussing a personnel matter and litigation. All those in favor? The motion passes unanimously. For those of you that have not previously joined us, at this time we ask that you all leave the BOC room. We will try to conduct this discussion as promptly as possible and invite you back. I've got your number, sir. Thank you. We'll entertain a motion to exit executive session.
I move we exit executive session.
Is there a second?
Second.
It's been moved and properly seconded to come out of executive session. All those in favor? The motion passes unanimously. We'll entertain a motion to suspend the rules to add an agenda item.
So moved.
Is there a second?
Second.
It's been moved and properly seconded to suspend the rules and further amend the agenda to add an agenda item. All those in favor? The motion passes unanimously. Mr. White?
Yes, so based on the discussion we just had in executive session, I would recommend that you add a motion to approve a settlement agreement between the United States of America and the Cobb County Board of Elections and Registration regarding the recent compliance review under the Americans with Disabilities Act of 1990, subject to final revision and execution by the board's counsel and its chair or her designee.
Is there a motion to that effect?
So moved.
Is there a second?
Second.
It's been moved and properly seconded to approve the motion to enter into a settlement agreement related to ADA compliance. All those,
I just want to make clear. So there was a motion to suspend the rules and add an item. I think we need to specifically, this one, what I was recommending was a motion to add this item. So
Oh.
so this is the motion to add that item, this specific item, and then I'll read it again to you and you can decide
Understood.
whether you want to approve it.
Yeah,
So-
that's my mistake. So the motion to add the item as stated, all those in favor? The motion passes unanimously.
Okay, and now that that specific motion has been added to the agenda, and we could have done that in the first one, and I could have clarified, I'm sorry. But, so now that that motion to approve, so I'll read it again and say, this is the motion I'm asking you to consider. It's if someone will make the motion after I read it. Motion to approve a settlement agreement between the United States of America and the Cobb County Board of Elections and Registration regarding the recent compliance review under the Americans with Disabilities Act of 1990, subject to final revision and execution by the board's counsel and its chair or her designee.
Is there a motion to that effect?
So moved.
Is there a second?
Second.
It's been moved and properly seconded to approve the settlement agreement between the Department of Justice and, the United States of America and the Cobb Board of Elections with respect to the ADA compliance review. All those in favor? The motion passes unanimously. Okay. I believe we are now at the conclusion of the meeting. Our next meeting will take place, it's a special called meeting that will take place on September the 30th, followed by our regularly scheduled meeting October the 14th, and in both instances, those meetings will take place here. On September the 30th at 5 p.m., the regular meeting, as per usual, October the 14th at 3 p.m. With that, the meeting is adjourned at 8:06.